Well, good afternoon, and Julian, thanks for joining me.
Absolute pleasure, Nigel.
As you can see, we are sadly all locked down in Sydney. I think, Julian, we're about 40 kilometres away from each other, so we're going to hope the technology holds up today. I think it's the first time Julian and I have done this online, so we'll see how we go. It's an interesting topic. We waxed and waned about whether or not we would do a webcast on industrial action. We've had some very strident advocates asking us to do it. So we thought today was a lovely time to do it. Julian, let me lead off, because I think there's some sort of fundamentals we've got to sort of talk through to begin with, and then we'll get into the nitty gritty.
Let's go.
Let's go. So, look, we'll probably roughly follow this scheme. As always, we'll try and take questions on as we go along. I think we need to talk a little bit about definition and history before we start. We're then going to get into this topic of the difference between unprotected industrial action and protected industrial action, and finish off really talking about how you kind of organise yourself to deal with industrial action and the psychology around it, because in many respects, the psychology is one of the key elements that people have to take into account. When you think about industrial action, the typical person I talk to always says that we're talking about strikes. That is, when people walk off the job or people go on strike for an extended period of time. I think the first thing that needs to be acknowledged is that the Fair Work Act has a definition of industrial action. It's a very tried and tested definition. It's appeared in legislation before the Fair Work Act in a very similar form. It appears in most state industrial systems legislation as well. And if you look at the definition of industrial action, you'll see straight away that it is very broad, and it effectively encompasses nearly every situation where somebody works differently to how they normally work, or declines to work the way they would normally work, or declines to present for work in the way they would normally work. And the exception to that, of course, is this notion of a lockout, where people are prohibited from actually entering the workplace to undertake work. But I think the first thing we need to say is it's a very broad concept. It's not just the notion of people going on strike. And very relevantly, you'll see there this concept of bans, limitations, or restrictions. And more often than not, the industrial action Julian and I have to deal with is more in the form of bans, limitations, or restrictions on the performance of work. That is, I'm performing some work some way, but I'm not performing all my work, or I'm not performing work in the way I normally would have done. So the first proposition I think that's important to understand is it's a very broad definition.
Nigel, I might add one thing there. I mean, the other thing, you can get this sense that, well, industrial action only happens during bargaining. You know, we've got this enterprise agreement and people are going on strike. It's a very, very broad test, and so long as it falls into one of those categories and it's industrial in character, not completely outside the realm of disputation or industrial or the workplace, it's gonna satisfy a tribunal that it's industrial action, and so therefore, as an employer, you might have an avenue to stop it, particularly if it's unprotected, obviously.
Yeah, and you obviously, as we'll talk about shortly, that triggers certain obligations as well as the employer in terms of what you do with pay and the like. So it's important to understand when conduct falls under this heading is the best way to put it. Now, I'll just jump ahead quickly. There is a circumstance where refusing work isn't going to be considered to be industrial action. And the most important thing to understand about this is it's quite contained. And it emanates in this situation. If an employee finds themselves in a situation in the workplace where they are in imminent risk to their health or safety, they're entitled to decline to continue doing that work. They have certain obligations after that. They must hold themselves in readiness. They must perform other duties or other work that is safe. But there is this one circumstance where if a person is in imminent risk to their health and safety, they're entitled to decline. That's a very localised concept. So if I just use the example, let's say that I was working on a drill and Julian was 40 metres away digging a hole nowhere near the drill, nothing to do with the drill, and I thought that that drill was unsafe and was putting me at imminent risk to my health and safety, I could actually talk to my supervisor and say, look, I'm really worried about this. I don't want to keep using it. That doesn't give Julian the right to stop work at the same time. So it's a very localised concept, but it's really important to understand that there is this one moment where people can say lawfully, I'm just going to decline to do that, and it's imminent risk to their health and safety. Outside of that, we'll just talk a little bit about history, because I think there is a little bit of a cultural issue with industrial action in Australia. For those people who are a little older than Julian, sort of my age, a number of things can be said about industrial action. You know, when I was growing up, certainly in the 70s and 80s, while it wasn't legal, it was certainly culturally kind of accepted that people went on strike. When I was in the early part of my career, 2, 4, 6-week strikes over the most silly arguments you could imagine were quite commonplace. My longest strike ever was an 8-week strike in the cement industry, and it was over how many pairs of socks people were going to get. Now, you might say that was stupid for both the employers and the employees, but there you go. When we got to the late 1980s, early 1990s, we had a big shift in our legal systems, increasingly, and also in our psychology. And we started to move into this notion in this country about whether or not our rights are settled or our rights are unsettled. And if our rights are settled, industrial action should be prohibited. If our rights are unsettled, there should be some scope for people pursuing their industrial rights through industrial action. And the other thing about history to remember, because this is quite early, is that up until about 2005, when we had work choices, a lot of employees and employers in this country operated in what's called compulsory arbitration systems. That is, if there was a dispute, industrial action wasn't the way to solve it. The tribunal intervening and actually arbitrating the outcome, if you couldn't cut a deal, was the way to solve it. So we've had this very unusual history where it was kind of culturally accepted but not lawful. We've moved into a world where it's culturally far less accepted, but there are circumstances where it is now lawful and clearly unlawful, and that's where we've shifted to quite quickly coming out of the 90s and then into the latter part of the 2000s.
It's the case, Nigel, isn't it, that industrial action is far less common now than it was in that time that you talk of before my time?
Yeah, Jules, it is. It's one of the great disappointments that the level of data collected by the Australian Bureau of Statistics is not as good as it used to be in this area. But on any statistical data point, credible statistical data point, industrial action has basically collapsed as a tool for pursuing. In my earlier days, you would probably be dealing with some form of wildcat industrial action almost every 48, 72 hours. Outside of bargaining, which we'll talk about, it's really unlikely to occur. And frankly, when you look at the amount of industrial action occurring in bargaining, it's actually pretty modest these days, even compared to what it was when we all started bargaining in the mid-1990s. So yeah, absolutely, it's come down. So that brings us to this notion that I just want the audience to sort of get about settled and unsettled. And in the world of the Fair Work Act, if you have an enterprise agreement and it's in its nominal life, all industrial action is unlawful. If you have an enterprise agreement and it expires, then subject to doing certain things, you can lawfully take industrial action. If you don't have an enterprise agreement, then in certain circumstances, again, industrial action might be lawful. So there's this notion of, do I have an agreement? Do I not? If I do have an agreement, is it in its nominal term? We're locked away, we're safe. Once it expires or I don't have one, then there are certain avenues for pursuing industrial interests through industrial action. I think it would probably be best if we talk about the unprotected, the unlawful side first, and then we'll come on and talk about the protected. And Jules, I might get you to run off with this. The 4-hour rule.
The 4-hour rule.
We talk about it flippantly, but what's the 4-hour rule?
The 4-hour rule is as put in the slide there, and it's meant to be a disincentive for taking unprotected industrial action. Because if you think about it, if you're taking unprotected action and maybe you don't advise that you're doing it, if you're only going to down tools for 5 minutes and you only lost 5 minutes of pay, it wouldn't be that big a deal. But the point is that if you take industrial action that's unprotected for less than 4 hours, you're going to be stung as an employee for a full 4-hour deduction in your pay. If the total duration of the industrial action is 4 hours or more, you're going to be stung for the total amount of the duration. Now, there's some technical stuff about overtime bans, and maybe we might loop around to that if you want to, Nigel. But the critical point...
Let's just give an example for a minute if we can. So let's say that we're a group of truck drivers.
Yep.
And we turn up for work and we've got an argument with the boss about how he's allocating us to the vehicles, and we tell the boss that we're going to have a meeting amongst ourselves. We normally start at 6 and we don't start work till 6:30. Tell me how the 4-hour rule applies.
Well, you've only down tools, or you've only refused to drive, or you've only engaged in the industrial action for the half hour. But because it's unprotected, that will trigger the 4-hour rule to say that you must be deducted 4 hours of pay, and makes, it's a strong disincentive not to undertake that kind of industrial action. What I was getting to, though, it's really important to understand that the 4-hour rule, it's a prohibition on payment. It's not a license to pay or not pay. It's a prohibition on payment. So you, as an employer, cannot pay employees. You cannot pay employees, whether it's 4 hours or more, should they take unprotected industrial action. Neither can employees request payment or accept payment. And so that's quite important in understanding the employer legal position, because if unprotected action has occurred, the advice you're going to get from lawyers is to say, not, should you pay, as you'll get the advice, do not pay, otherwise you'll be in breach of the Fair Work Act.
Now, let's just go through that. So in the situation that we described, where the drivers didn't work for half an hour, the employer is obliged legally to deduct 4. If the employer doesn't do that, they are themselves breaching the Fair Work Act. If the employees come to the employer and say, "Oh, come on, mate, fair cop, pay us for the half hour," or don't deduct the 3.5, they are themselves in breach of a particular provision of the Fair Work Act as well.
That's right. And I mean, essentially what we're talking about is strike pay, I think, is the old world phrase. And the Fair Work Act prohibits strike pay. I should just loop around to the idea of what industrial action isn't. Obviously, if you allow your drivers in that scenario, Nigel, to have their meeting, if you say, look, have your meeting, just be back ready to drive by 8:30 or whenever it is, that's not industrial action. So behaviour or conduct that's endorsed or not tolerated, but endorsed by the employer is not industrial action. If that happened against your direction, you would be stuck by the 4-hour rule, and you'd have to deduct payment.
And I think the important thing there is that if the employer is going to authorise that behaviour, they've got to authorise it before it occurs. They can't They can't retrospectively authorise it. So if somebody came to me and said, do you mind if we have a meeting for 30 minutes in the yard? And I said, look, that's fine. I'm going to put that in writing to authorise that you can have 30 minutes. Then we're all good because it's an authorised meeting. If they just walk off and have their 30 minutes, it's unprotected, 4-hour rule kicks in. And unfortunately, the employer can't retrospectively authorise that to get out of the 4-hour rule.
You say unfortunately, Nigel. I mean, from my perspective, this I think provides some comfort to employers who are facing unprotected industrial action, because it provides whether you call it an excuse or a get out clause or whatever you call it, you are bound by the Fair Work Act to deduct the money. It's not because you're a Grinch or an awful employer. That's just the law. It's just the law. So that's my maybe unsympathetic take on it.
Now, let's say that those drivers had their 30-minute meeting and they walk in my office and say to me, look, we're not working for the rest of the day. We can race off to the Fair Work Commission and get it fixed, right, Jules?
We can. It's a 418. They're very exciting and fun parts of our job. The interesting part is the arrows there. Obviously, a 418 will apply to
This is the Fair Work Commission ordering the cessation of that activity.
Yeah, and it's activity that is happening, is threatened, impending, or probable, or being organised. And there's all manners of ways which you might find out things are being organised, things are being threatened, or things are probable. Sometimes the threshold question before the commission is, well, is this actually going to happen? And therefore, do we have jurisdiction to provide or to make the stop order? But if you'll see there, in terms of how 418 works, the commission must make an order. So they are compelled to stop unprotected industrial action. It's not a question of discretion. Well, we'll let this unprotected industrial action go this time. If it's happening, if it's threatened, if it's being organised, the commission must stop it. And all these things are very urgent. Sometimes, I mean, practically, strategically, Nigel, the threat of making a 418 application or the filing of it tends to make unprotected industrial action disappear or be called off, particularly if the organisation or the employees are well represented by a union or someone who knows what the law is. Once the 418 application is made, and if it's clearly unprotected, the employees know that they're going to cross the line in terms of the Fair Work Act.
Yeah, I think it needs to be said that this is a 48-hour turnaround. It's sometimes a 24-hour turnaround. If it's really inconveniencing the public, the Fair Work Commission will sit late into the evening to get it all sorted out. But this is a very quick turnaround, as you said, Julian. If it's threatened or happening and you prove it, they must make the order to stop it if it's unprotected, and it's a very effective way of bringing to an end that type of unprotected industrial action. And as you say, sometimes quite exciting, Julian. Very
exciting.
Now, I have to confess that Julian decided to pick the picture of Millhouse. He's going to explain why in a moment. I've got no idea why Millhouse got on the slide. Maybe there was a bet that one day we had to put Millhouse on the slide. I'm not sure. There is this notion, and you hear this phrase a lot, the blue flu, go slow, work to rule. In other words, you sometimes see people who are doing things a little differently, but you're worried that it's hard to prove. And I think this is what you would call, Julian, covert industrial action.
Exactly. I mean, Millhouse is my homeboy. He's very hard to see in that picture because he's wearing a camouflage suit. Now, sometimes industrial action can be very hard to see because it's not notified. There isn't a union identifying that, look, we're going to go on strike or we're not going to answer our emails. It will just be industrial action that employees amongst themselves decide to do. I've put up 3 case examples for the more diligent of attendees if you want to go have a look at these cases. The actual principles are pretty straightforward. I mean, if it's unprotected industrial actions, the Commission has to stop it, as we've just said. But the reason why I put these cases up here are just examples of where covert industrial action might be happening, and it's not immediately apparent that it's industrial action because it's covert. The first case is just a case where a group of employees just stopped volunteering for overtime. They just stopped amongst themselves. They didn't tell anyone they weren't going to volunteer for overtime anymore, but the employer realised that they'd stopped volunteering for overtime. The second case is about train drivers calling in sick and causing train cancellations. The last case I've put in a tiny bit more of a description of a 5-employee shift where no employees showed up. And there was a case run on it. 3 of the employees gave evidence. 1 had a sick son, 1 had a cold, 1 had something in his throat, and the other 2 had excuses so poor that they weren't even called as witnesses. But the point is, and I think it is a short point, Nigel, is if this is happening, and we would say, and please jump in here, Nigel, we would say if this is happening, have a go at proving it. See if you can run reports to say, actually, the absence rate is way too high. There is something going on here. Or the volunteering rate for overtime is way too high. There's something going on here. If you can prove it, you're potentially in the ballpark for a 418 application.
And the most common time that we tend to see this is if the business is sort of going through a change process and the employees or the union aren't very happy, but they can't legally do much about it. You often see these kind of campaigns of resistance. And Julian's right. If you see a campaign of resistance, I would say give us a call because we're probably going to be able to explain to you how we can flush it out and how we can try and get some relief in terms of those campaigns of resistance. Just don't wear them. Give us a call and we'll take you through that. And we'll say goodbye to Millhouse. Now that's kind of the unprotected world. That's the world where it's all very clearly unlawful. We now come to the protected world, and the protected world only arises in bargaining. And I'm going to take us through this as effectively as we can, but I will say that if people want to really get into this, they probably should book into one of our bargaining training sessions because we'll go into this much more broadly in the context of both strategically and tactically thinking about bargaining. So industrial action in the realm of bargaining. And if you think about the bargaining system, and please don't get too stressed, we've deliberately blurred parts of this slide just so that we don't divert attention. That is for the engineers on the line. That's a schematic of how our bargaining system works. We could have made it more complicated, but we try not to. We're really talking here about we don't have an agreement, or we have an agreement that's expired. There is a process then to legally take industrial action called protected industrial action. Firstly, it involves this thing called a protection action ballot, which we'll have a chat about, and then certain rules and procedures around how you actually take the action. And we'll have a bit of a chat about some examples that have come up over the years, which are quite interesting. The first thing that needs to be said, and Jules, you might jump in, when you actually take protected action, you have certain legal protections, Julian.
Yeah, that's right. I mean, you're going to be able, under the Fair Work Act, to take it. But there's also immunity from, for instance, you couldn't be dismissed for taking protected industrial action. That doesn't extend to more extreme forms of even if they're protected industrial action, which could result in injury, reckless destruction of property, or unlawful taking of property. But basically, if it's protected, as the name suggests, you're on firm ground to take it, and you're not going to have a case made against you as an employee or as a union. The other aspect of it, unless you want to jump ahead, Nige, is in terms of I think the most important thing to say, Nigel, about the concept of protected action is, as you say, it's in a bargaining cycle. And so it can't be taken before the agreement's nominal expiry date. And if you can think more about industrial action in the context of bargaining as opposed to necessarily a broader concept of employee-employer relations, it starts to make more sense. You can only take protected action when you've tick all of the boxes. One of those things is your agreement's expired and you've done the things which you're about to click through in terms of ballot orders.
Or you don't have an agreement, and there's an agitation to actually move to actually have an agreement. It's in that sense, and it's very important. This is probably why it's dropped off dramatically. One, there's far more effective recourse when it's unprotected now than there used to be, while it is now protected and allowed in certain circumstances. They're very limited circumstances, and I suspect that's one of the reasons why we've had so much drop-off in industrial action. The first thing you have to do, let's say we've got an enterprise agreement. Let's say it's expired. Let's say we're dealing with Transport Workers Union. I'll pick on the TW today. Michael Caine won't be too upset with me doing that. We pick on the TW. The TW is the person we're principally representing our employees. If they want to take industrial action to be protected, they have to have what's called a protected action ballot, which in our world is called a PARBO. Everybody loves an acronym. It's an application to the Fair Work Commission. It gets dealt with very quickly. It gets dealt with in the first 48 hours of it arriving. You will get a chance to respond to it. 99% of the time, we tell our clients not to waste their money responding to it other than to say, we're good with it. That application will be in a pro forma form. The union movement are pretty good at this. And it will basically identify a list of potential actions to be taken that they want to have a vote on whether or not it's supported to take those actions in the future. There's a number of really important tactical issues about this. The first one is you'll see there, the bargaining representative makes the PARBO application. And in that sense, the only people who ultimately will be protected are the people the bargaining representative is actually representing in the negotiations. So if you think about a workplace where, let's say you've got 5% union membership and the union apply for the PARBO, only 5% of your workforce might ultimately be allowed to take protected industrial action. It's a really important tactical issue to understand. So let's say they file the claim for the PARBO. They've got to prove that they've genuinely attempted to bargain. Frankly, that's a pretty low hurdle. A couple of genuine meetings will get you there with that. And then there'll be a ballot. More often than not, the ballot's conducted by the Australian Electoral Commission. Maybe about 4 weeks to get set up, depending on how busy they are. Increasingly, unions are paying to have private sector third-party ballot providers do it. But it's normally around that 2 to 6 week process to actually have the vote. The people who can vote are the people the bargaining representative is acting for. The Fair Work Commission will work out who they are. And then it's 50% of the persons the bargaining representative is acting for voted, and 50% of those voting voted for the action. So if I've got 13 people who are eligible to vote, I need to get 6 of them to vote, and at least half plus a bit have got to vote the thing up. And when you actually see how they actually vote against each item. So it might say something like this: unlimited number of single-day stoppages, yes, no. Unlimited number of half-day stoppages, yes, no. Bans and limitations on the performance of paperwork. Bans and limitations on the use of computers, the relatively standard kind of laundry list of things that get voted on. There'll be a return of the vote from the person conducting the ballot. The good thing is you get to see the return, and you always get to see how many people were lawfully allowed to vote. In other words, how many people that person's actually representing, and you'll get to see which forms of action were voted up. In my experience, they nearly always get voted up. Every now and again, you get a sort of a left field moment, and certain action is not voted up. So it might be they voted up 8 out of the 10. And just every now and again, you don't actually get it voted up. Would that be your experience, Jules?
It is. And in terms of the laundry list and unions being good at these things, I mean, certainly there's a lot of template documents out there for PARBOs. And you also mentioned wasting, the waste of time trying to weigh in to contest parbos or contest the wording of parbos.
Assuming it's all in order.
That's right, but I think it's a fairly broad scope of order. The time for an employer to really get the forensic magnifying glass out is not when the parbo is listed or run, and to really forensically look at the categories that are put in these documents that are voted up. The time to be very, very precise is when the action is actually notified down the line. Because what the ballot order is doing is that it's trying to set up an authorised list of actions that employees can take. So I'm not as stressed about what goes into a parbo, voted up, whatever. Questions are voted up, people vote on it. I guess my concern and where I get interested and where I say employers should get interested is down the line when the action is actually notified. We are going to take this action. I want to go back to the parbo and check, well, did they vote this up? Does this fall within the scope of what the parbo actually authorised? And the commission is going to be far harder on that question as opposed to what goes into a parbo.
Yeah, I agree with that. Which brings us down. So let's say that in my case, the drivers, we're bargaining with the drivers. We've had 3 or 4 meetings. The TW's applied for a protected action ballot order, and they've got it up. There's 10 lists of there's 10 items on the list: bans, limitations, strike action. You name it's on the list. There's then some before they actually take the action. There's some fairly important rules to understand. There's obviously the one that Julian talked about earlier several times to really reinforce, and that is they can't actually start the action until the enterprise agreement's expired. It's really important to understand that. They can get the parbo before, but they can't take the action before the agreement actually expires. And then we have this very famous thing called the 3-day rule. And effectively what it means is if they look at that list and they go, we're going to do number 4, they've got to give the employer 3 working days notice that they're actually intending to take item number 4. They've got to explain what day that's going to commence on and any details surrounding that. 2 things about that 3-day rule which are really important to understand. There is an ability to get more than 3 days, but we need to understand at the time of the parbo if that's important. It's very rare to get more than 3 days, but if you're in an essential type of industry or you're in an industry that has critical supply times, just-in-time type supply times, you can sometimes get 7 days, 5 days notice instead of the 3. But the 3-day rule applies, and as Julian said, it's at that point where if you get the letter from the union saying we're going to take this action starting next Friday, the first thing we will do is we will want to compare what's in that letter against what was on the parbo list to make sure that the action is actually properly been voted up to be taken, and also to make sure that the details in that letter meet the 3-day rules. I think that's the point you were trying to make earlier, Julian.
Absolutely, because if it's not authorised by the parbo, it's not going to be protected action. I should just say there, even if you have a win and you work out, this notification 3 days out, it's not covered, the parbo doesn't cover this action, or maybe it's 2.5 days, and you say, you write back to the union or whoever it is saying, well, I've got you. You're not gonna be able to take the action.
They just reissue it.
They just reissue it. So these aren't. This is an ongoing process. So you need to be aware of the fact that in these process related things, these little wins might be fun, but you're not going to be able to bar them from just issuing another notice and then taking it slightly later.
It's a nice little tactical moment, but it might not actually achieve a longer term outcome. And the only other rule that's really important is this rule of this concept of the 30-day rule, which is basically once the parbo's been issued, they've got 30 days to start taking action. Sometimes when unions apply for a parbo, just as a tactic, you sometimes find that they actually quite strangely forget to take the action and they have to go back to sort of square one and start again. although they can also make an application to extend that 30 days. So we tend to keep our mind very closely aligned to, after they've got the parvo, how quickly are they likely to take the action. And sometimes you see a union get to day 29, and it gets to day 29 and it'll do something just because of the 30-day rule, even though it probably doesn't need to. So just be aware. But the really important one there is the 3-day rule. Now, we over the years, there's been some really fascinating cases about the 3-day rule. I'm sad to say that some of the early cases I was involved in, retired Justice Bolton was involved in as well, and Alan Bolton and I probably never got on that well. There was a very Julian's worried about me even admitting that. Lovely guy, really lovely guy. We had a case very early on. And the question was asked: Can the union rescind the letter giving 3 days' notice unilaterally? So, in other words, can it say in 3 days' time we're going to do something, and an hour before it starts say, oh, by the way, we're not doing it? And of course, the other question you often get is, having got the 3-day letter, the other question you get is, well, what happens if they just turn up for work anyway? So just be mindful of, there was a very famous case very early on. It was a quarry on the south coast of New South Wales, predominantly loaded most of its quarry material on a train. Train was loaded twice a week. Union put in a letter saying, well, we're going on strike an hour before the train needs to be loaded on Friday. An hour before the industrial action was meant to commence, the union would ring up and say, yeah, we're not doing that anymore. And of course, the company had already made alternative plans how to load the train and therefore bore the cost. Unfortunately, the Fair Work Commission said, yeah, they can do all of that. That's all part of bargaining. Interestingly, they said that might not necessarily constitute bargaining in good faith, but just be mindful that there's a lot of shenanigans and can get played around with this 3 days. Once the 3-day letter is issued, doesn't necessarily mean the action's going to actually occur. Your views, Julian?
My views would be simply this. Sometimes I think people can forget that industrial action is meant to hurt the business. I mean, it's meant to affect the business. So whether it's shenanigans around the 3-day rule, whether it's the cost that the protected action is going to incur on the business, or the clients being unhappy or customers, all of these things are kind of the point of industrial action. And you're going to have to be in a real exceptional case to get much satisfaction from the commission to say, oh, actually, in this case, yeah, the price being paid by the business is too much. For shenanigans around the 3-day rule, unfortunately, that's just something that even the commission will say openly, look, you're just going to have to wear that.
Yeah. It's part of life. Move on. Yeah. There's one very important distinction with some of this, and it's an important rule, and it tends to take a bit of explaining. We'll just do it reasonably promptly. If you have a ban or limitation, not a strike. So let's say that the employees say we're not going to use computers anymore. So let's say the truck driver said we're not going to enter any information into the onboard computer system. You've got some slightly different ways of responding to that, to the way you would normally respond to strike action. You can accept that they're doing that and just let the industrial action flow. You could actually decline to provide them any work and basically tell them to go home until they're prepared to do all their work. Or you can do this very interesting and somewhat funky thing, which is you can estimate proportionately how much time that was meant to take, and you can reduce their pay accordingly. And there's some really interesting issues about these deduction issues when you have bans and limitations. Sometimes tactically we'll often tell a client, look, just wear it, because they'll get tired of it. Sometimes we'll tell a client, look, we need to do a deduction assessment because they've got to feel some pain, particularly when you're transactionally negotiating rather than relationally negotiating. And so there is this very different way of responding when there is a partial work ban in place. There's a very famous case involving the ACT bus company. TW, God, I'm picking on the TW badly today, aren't I? TW, yeah, I'll get some phone calls afterwards. The TW members down there during bargaining got a parbo and said they weren't going to collect fares back in the time when fares were quite a few amounts of money were collected through fares. The company said, well, that's a ban. We're going to deduct a certain amount of money from your wages. It ultimately ended up in a dispute in the Commission as to whether or not the assessment of the deduction was fair. The Commission has a general discretion in those matters, and it was comfortable that there was approximately a 20% deduction in pay, even though the amount of time taken not collecting fares was small. The consequence of it was quite large, and so they allowed a 20% deduction in pay. And it's probably one of the more famous cases, Jules, I think.
Yeah, that's right. I mean, it shows the different test applied for an employer to the Commission. It's a really interesting position when employers are facing these decisions because they do kind of have to go a bit off script. The Fair Work Act doesn't necessarily precisely identify exactly what you're meant to do, and there's a strategic question whether you do it or not. You just, and your point is excellent before, Nigel. This is about a bargaining process. It's about a negotiation process. And strategically, the right call might be just to accept it and take the high ground and see if you can, by doing that, get enough goodwill so you can win a vote with the people who maybe aren't involved in that. Maybe you want to, as you said, inflict make the ban hurt a tiny bit. Or in some cases, you might say, well, we can't actually wear this at all. We're not going to accept you working in this partial way. Don't return to work until you're willing to perform the full scope of your work. So it's all about the circumstances, and it's not just about the particular incident or the particular action that's been taken. It's in a broader context of bargaining, and you need to know what you're trying to achieve with bargaining. And I'm sure you'll get to that later in the slide pack, Nige.
Now we might move along a little quicker because time's getting away from us. Look, the primary tactical way the legislation allows the employer to respond to employee action. So if the employees have gone on strike, by way of example, in bargaining, it's all protected, it's all lawful. The primary way to deal with that is by a lockout. I'm not going to go into lockouts in any great detail. It's important to understand that they have to be in response to employee action. That's proposition number one. And proposition number two is if your bargaining has ended up in a place where this is being considered and you come and talk to us, we're going to talk long and hard with you about whether or not it's got bad enough to do this. There's some phony lockouts have occurred in Australia where people allegedly were locked out but really weren't. If you seriously lock people out, our advice is always you got to do it till you win. And from experience, and I've been involved in 3 major lockouts in my 35-year career, you can take 5 to 10 years to recover from a serious lockout culturally. So just understand that it's available. We won't go into it in any great detail, but if you are involved in bargaining and this is being talked about, I would be really urging you to come and get some advice, not just about the legalities, but about the cultural implications. There are a variety of ways, even if industrial action is protected and it's legal, there are some ways of trying to stop it. They're very limited. I'm not going to go into them in great detail today other than to say they're there. There's a couple there which are interesting. So if you're suffering significant economic harm, and I literally mean it's driving you into insolvency, you can stop it. The one at the bottom's a really cool one. Significant harm to a third party. So this is the classic case of the brake pad manufacturer is bargaining. They're on strike in a protected way, and the Ford Motor Company can't get its brake pads, so it can't operate. Ford Motor Company could step in and say, you've got to stop that even though it's protected because it's fundamentally damaging our business. And probably the other one that's interesting is the endangerment to personal health. So you often see that dropped on the table if, nurses go on strike or doctors go on strike or things like that. So there are some limited ways of either stopping industrial action that's protected or some limited ways of getting it suspended for a while. And if you are talking to us about your bargaining process, we'll obviously take you through that at the time. But importantly, they're very limited in when and how they apply.
Have to wear a bit before you even get in the conversation of those types of things. And for some businesses, they'll never get into that conversation.
They'll never get there. People always talk about Qantas, and my response is, yeah, well, okay, are you the national carrier in Australia? And they go, no, we run a footwear factory, and so just don't.
Qantas is pretty niche, I would say.
Qantas is very niche. It has some delightful nuance about it, which isn't always in the public domain. Look, the one thing we all say to a client is, if you really are in this environment and it's industrial action, protected industrial actions likely, what's your business continuity plan? And I know that might sound pathetic in a way, but it's really important to have one. Sometimes with clients that involves, bringing in supervisors who've retired over the last 5 years to get back on the machinery. But it's really important to have a business continuity plan that's a commercially sensible thing to do alongside what might be any tactical or legal strategy that we're obviously supporting you through. Just be aware the Commission can help you. If you are in a bargaining dispute, the Fair Work Commission can conciliate that dispute. Sometimes they're very good at that. Sometimes they tend to be a little standoffish for me. There are some unions who hate being taken to the Fair Work Commission to conciliate a bargaining dispute. And sometimes if you really are, again, in a quite combative environment, that's not a bad thing to do. Just be mindful that you can't ask the Commission to arbitrate to solve the bargaining dispute unless all the bargaining representatives consent. But if you really are struggling and it's getting a bit ugly, that Commission could be a very good device as a sort of third-party intervener to try and sort of do a bit of conciliation, mediation to bring it to an end. And not something that happens in all the sort of bargaining disputes I get involved in, but I'd probably say at least a third of them, it's not a bad thing to think about. And let's just maybe spend the last 10, 12 minutes talking about prep and psychology. And then, Julian, I know you've been watching the questions, see if we can just knock a few off. I apologise up front if this language is a little bit pointed. If I'm dealing with people who live in a very industrialised world, I say these three things to them before we start bargaining. Clean your house. What do I mean by that? Get out of the way before you bargain. Any unsolved grievances or niggles or problems, go and get your safety person to go and do a safety audit of the factory or whatever it is that's involved in the bargaining. In other words, don't leave things festering before we start, and please don't leave, particularly if you're dealing with very combative unions, please don't leave yourself exposed to safety issues, because that's the thing they'll pick on before they get to the protected industrial action. So number one, clean your house. Number two, if people have been earning 40% of their income over the last 6 months through overtime, don't be shocked if they're going to be more inclined during bargaining to take industrial action than less inclined. So just understand, are you fattening people up with lots of overtime, lots of extra income? And the third one I'd say in getting ready is, look, be smart commercially. Do you need to stockpile? Do you need to actually have effective commercial contingency in terms of how you're going to supply customers, if that is available? For some businesses, logistics, it's not. But those are the three things I would say before you start in terms of getting ready for industrial action. There's probably three things, probably a good way to sort of finish today if we can. You know, when should you expect it? And proposition number one is it culturally accepted? Proposition number two, have you taught them to do it? And the last one is a little bit about combative unions. And let's be frank, not all unions are combative. Some unions are incredibly constructive, almost take a partnership role in some of our clients' businesses very effectively. The cultural one's really important. And I'll just jump ahead. If you think about this way, and if you look at that slide, if you think about the vertical axis, if you think about the top of that axis represents progressive culture, very engaged culture, and the bottom of that vertical axis represents regressive, very disengaged culture. If I've got the horizontal slide then, on the right-hand side of the horizontal slide, I might have very limited, if no union activity. And on the far left, I've got very strong, perhaps aggressive, invasive union activity. Bottom line is, the stronger the role of the union, the more regressive your workplace culture is. During bargaining, there's more likelihood of industrial action to resolve problems. The more progressive your culture is, the less unions are a feature, the less likely it is for industrial action to occur. So the first thing that I always say to everybody is understand whether or not you are more culturally receptive to industrial action during bargaining than not. It's really important, question number one. Question number two, Julian's going to chuckle because he knows I always like to get Pavlov's dog in, but you know, beat me with Millhouse, I'm very conscious of that. If in the past in bargaining, industrial action has succeeded, what do I mean by that? Julian's put his best offer, we go on strike for 2 days, and Julian now puts his new best offer. What have we taught our workforce? We've taught our workforce that if they go on strike for 2 days, they get a better offer. And one of the questions we'll always ask our clients is, well, what's the learnt behaviour in the past? Have we demonstrated that industrial action succeeds? And if we have demonstrated it succeeds, don't be surprised we'll see it again. Now, that's easy for me to say because I'm not the one who's exposed to the commercial reality of the industrial action. I'm not being righteous about it. Sometimes you've got to make pragmatic decisions, but you do need to be mindful that if in the past it's succeeded, don't be shocked they'll try it again. And I think, Jules, that's possibly a stronger determinant of whether or not it's going to occur than almost anything else.
I think that's right. I mean, for those on the line today, proportion of the people might just be interested in the topic, but a large proportion, I imagine, are in organisations where industrial action is a part of the bargaining cycle. And there are many people who are not on the line today. Industrial action couldn't be any further away from their organisation. The question I would ask is, well, how does industrial action become a part of a bargaining cycle? I would say, based on your little canine friend on that slide, it worked last time. This is what we do. We do industrial action to get the outcome, as opposed to some other way of negotiation, which gets two different views and then gets to a final result. I mean, it's a pretty blunt instrument if you think about it, but if the blunt instrument has worked before, why wouldn't you do it again?
Yeah, and so if we're involved with clients around bargaining or we're doing bargaining training, we'll talk about this in the context of transactional bargaining versus relational bargaining and all the things that go into the mix of this. But this notion of learnt behaviour and was it successful is a real key determinant about whether or not next time it'll happen again. And sometimes you have to re-educate people around that, and it takes a bit of pain sometimes to re-educate.
Nigel, the other... Sorry.
Go, mate.
I was just going to say, I mean, again, it's in the broader context. It is not just a question of they want to do this particular protected action on this particular day. That's in a context of one agreement that you're trying to negotiate, and that negotiation of the agreement is in the context of every other agreement you've negotiated, which is in a context of your whole relationship with your staff, between the staff and the employer. So you actually need to get quite big picture about all of this to understand how each of these small decisions in relation to protected action will have an effect on the broader scale.
Absolutely right, because you start to create an environment that everything is actually occurring in, and that environment has a very strong impact on outcomes as you progress year in, year out, bargain 1, bargain 2, enterprise agreement number 4, 5, 6, 7 and 8. There is one point I want to make about if you're in bargaining and you are confronted by industrial action. I had a client say to me a couple of weeks ago, don't the union want to make an agreement? And I said, yeah, probably not. I think the real reason reason why they're beating us up at the moment is they're having a great job. You know the client I'm thinking about. Their membership's gone up by 100% since they started this. They're demonstrating that they're exerting control and influence in your business, and that's making their members feel very comfortable and attached. And because they've gone on strike and it looks like it's working during the bargaining process, the union's reinforcing its need and value, and that's why everybody's going to keep paying $1,200 a year to the union. So just be mindful that you might be hit by industrial action that might have some underlying strategic role that isn't necessarily simply about the new agreement itself and getting the new agreement. And that's a nuance that sometimes we have to work through with clients, because a lot of clients just go, well, surely this is just about getting a new agreement. No, it's not. Quite often it's about how does the union increase its role and its membership in your business, and we need to have a good talk about that. And industrial action is used sometimes to galvanise people around that concept. And perhaps we might just finish off, Jules, is just talking about the motivation, and I think you touched on this before. It's meant to hurt. It's meant to make you feel impotent. It's meant to make you feel frustrated. It's got a very deep psychological element to it. And I know, over my career, I suspect over yours, Jules, you see people really struggle, because you'll see people who are values-based leaders. You'll see people who've got a very strong view about employee engagement, and they find themselves in a bargaining context. They're hit by some industrial action. It's almost a personal affront to everything they stand for and what they've tried to achieve.
Yeah, I can't believe they're doing this to me. After all we've done for them, particularly with family businesses occasionally, which are successful enough to grow and grow and grow, and maybe they didn't have a union presence before, then they get one, and then they get into bargaining, and then they get into industrial action, and it's exactly right. You're running your business one day, and then the next day your staff are saying they're not coming in, or they're not gonna do the thing that you've asked them to do. It can be very, very disruptive and upsetting to those running the business. And
I'm thinking of a case you and I had 3 or 4 years ago with a rural business, large rural business. They said, we felt betrayed. It was so. I think it's really important for the audience to understand that it's designed. Industrial action is a form of coercion. It's designed to get under your skin. It's designed to economically hurt you. It's designed to psychologically hurt you. And sometimes it can be taken very personal. So we often find when we're working through bargaining and industrial action is involved, particularly to the less experienced, there's a very important conversation about how you're coping with the psychology of what it's doing to you and your sense around the workplace. I think that's we've probably done industrial action justice over 60 minutes. I suspect we could have taken 3 or 4 hours, although we probably would have been described as being quite nerdy by the end of it. Jules, I think we've got a couple of minutes left. Are there any really good questions that have come up?
A couple of questions have come up, but they've almost all been answered within the scope of what we've talked about 30 seconds after they've been asked. So I think for any of the remaining questions, we can follow up those people privately. And I think it's probably as good a time as any to describe how we can help.
So look, as we said, particularly if you're interested in the bargaining process, we run some pretty effective online during COVID. Sadly, we normally used to run them live, but we run a bargaining program that runs over 2 days. If you really, that's going to not just talk about this, it's going to talk about strategy, tactic, culture, you name it, it's got it all there. And we often use that program to persuade people not to start bargaining and talk about what their alternatives might be. But if there's any issues arising from today, or if you do find yourself beset by what you think is industrial action, as always, drop us an email or give us a call. And other than that, as we've been saying now for a little while, Julian, I think I saw the numbers today in New South Wales. They're horrifying. They're creeping up. I suspect we'll be online for a little while longer. But if you are currently locked down or in and around a lockdown, I wish you well. I hope your business is surviving. We will get out of this, and please stay safe, and we'll talk to you shortly.
Stay safe, be well.